Hi, Tony DeWitt here, Missouri Appellate Attorney and a guy who likes to make the law make sense on YouTube. Today we're going to talk about one of the more boring subjects in the law called evidence, particularly in the context of the Scott Peterson Parkland shooting trial. So let's get into that. Among the motions filed by both sides in a trial are motions in limine. Now, limine is spelled L-I-M-I-N-E, not L-E-M-O-N-Y, and the motion in limine is designed to limit the amount and type of evidence that the other guy can put in. So you might file, for example, in a traffic case to keep out the consumption of alcohol prior to the traffic accident if, in fact, there was no evidence that the person was intoxicated at the time of the crash, because it probably isn't relevant. You can file those motions and it's up to the judge to grant them. But even if the judge grants them, you still have to make the offer of evidence if you want to object to the judge's ruling. So there are all kinds of procedural things that have to be done in a trial in order to get evidence admitted. And a good lawyer will not give up on an evidentiary point if he is busy making a record. So this first vignette that we look at today is Scott Peterson's defense lawyer making an argument about the motivation of the officers who investigated his client, Scott Peterson. Let's take a look at that now.
This is the judicial branch of government. Your client's pled not guilty. We're going to introduce facts in this case, and the jury gets to decide.
If Sheriff Riddick's testimony, I proffer to you because I took his deposition, is we only conducted a criminal investigation because the governor
No, I'm not going to let you say that in front of the jury.
ordered us to, and that came after this famous press conference, which got picked up everywhere.
Mr. Agash, you're not listening to me. Now we're behind schedule. So why does any of that matter?
Judge, not only do
What question does the jury have to be asked? I'll ask you again. What issue does the jury have to decide that has anything to do with anything that you've just talked to me about for the last 17 minutes?
whether there's bias, motive, interest on the witnesses, in the witnesses' perspective, and if they saw that press conference and it impacted them, then it's
You
relevant.
didn't ask them.
I plan on, because quite frankly, you shut me down, Judge. I was going to get into that area.
No, sir. All you have to do is tell me what you want to do. I'll send the jury out. We can do a proffer outside of the presence of the jury if you
Okay.
think that I'm ruling incorrectly, and we can go from there. But what one investigator or 100 investigators decided to do or didn't do, and what their motivations for doing that were or were not, is totally irrelevant to what this jury has to decide. Your client is charged with these crimes. This is his trial. And the jury will decide if the state has proven beyond a reasonable doubt whether he's guilty or not of each element of each crime. But they're never going to hear me read, why did Scott Israel do what he did? Why did Investigator Riddick do what he did? Why was the defendant charged with the crimes that he was charged with? That is not the purview of the jury. Therefore, none of it is relevant evidence.
Okay. If I'm saying he's not guilty, I believe that I have the right to say these charges were politically motivated.
Well, you are incorrect, sir, but you're entitled to your own belief. But in this courtroom, my decision on what's relevant or not is
Well, I'm going to certainly respect it and respectfully disagree with what I'm
All right,
allowed
well,
to
Mr. Igars, here's what we'll do then. You come back tomorrow or after the lunch break or any day, and please bring me any Florida case, any Florida statute, any rule of criminal procedure that says the motivation for criminal charges is relevant. I invite you to find one Florida case in the history of the criminal courts of Florida where the decision to make a charge or not make a charge is relevant, admissible testimony. Anything else, sir? We're done with this subject.
Yes, but on that first issue that I brought out, what a witness saw and where they got their information from prior to testifying would be relevant.
No, what a witness saw and where they got their information from about what they're testifying about.
Yes.
About February 14th, 2018. That is relevant.
So I would like to be able to ask witnesses, did they see Sheriff Israel's press conference, and if that influenced them in any way in formulating the facts about which they're testifying?
You just said, did someone's press conference influence their version of the facts?
Yes, sir.
Well, I think you just made my argument for me, sir. Okay, anything else?
No.
Okay, very good. Please bring the jury. State you have
So let me see if I can put a little bit of additional context here. It's obvious that the state has filed a motion in limine to keep out information about the motivation of the investigating officers. And doubtless both parties briefed that before the court. In other words, they filed suggestions in support and suggestions in opposition. And the judge likely did his own research in addition to that and made a ruling. And he excluded that information from the jury. And as you saw in that vignette, he told them, look, that none of that information has anything to do with the elements of the crime that your client is charged with, and we don't need to get into the motivation because it's not relevant. But he keeps coming back and he keeps arguing, and he makes a big record here so that he can, if he wants to later on, go up to the appellate court and say, you know, I tried to get the judge to do the right thing here, but he wouldn't do it, and it infected the trial. Because if these people had known that my client was strung up by the governor, they might have decided things a little differently. Of course, that essentially means that they hadn't been paying attention for the last 2 years, but I would assume that most of the people understand how this case got in front of a court to begin with. But that's the role of the defense attorney, which is to challenge the state's evidence at every turn. And I thought he made a good argument on a very weak premise. In other words, if it had been me, I doubt if I would have tried to get that information in, because it clearly is irrelevant. He either did what he did or he didn't do what he did, and why they investigated him is irrelevant, because they did investigate him and they made these charges. So next we're going to look at the testimony of a crime scene investigator. And the purpose of this is to give you a bit of a understanding of how evidence gets admitted. You'll watch the rather painstaking way that the prosecution goes about establishing who the person is, why they were there, what their job was, what they did, and now can they validate these photographs. So let's watch that.
Can you please state your full name and spell your full name?
My name is Detective Danny Christian. The last name is spelled Krystyan.
Danny?
Correct.
Mr. Kilburn, you may inquire.
Thank you. Detective Christian, where do you currently work?
I currently work for the Broward County Sheriff's Office. I've been with the Sheriff's Office for approximately 22 years, and I have a total of approximately 27 years of law enforcement experience. I'm currently assigned as a crime scene detective, and I've been with that unit for approximately 9 years. Prior to that, I was a road patrol deputy, and prior to that, I was an officer at Waverly PD in Waverly, Ohio.
Now, back on February 14th of 2018, were you assigned to the crime scene unit at that date, at that point in time?
Yes, sir.
Okay. Now, in regards to what occurred at Marjory Stoneman Douglas, were you tasked with doing anything specific
Yes.
with the building?
I was assigned as the lead forensic detective for the first floor of Building 12 in the Marjory Stoneman Douglas campus.
Did all of the work that you conducted take place in regards to the first floor?
Yes.
Now, as a crime scene detective, what were you tasked with in February 2018 for the 1200 building at Marjory Stoneman Douglas?
So as a forensic crime scene detective, our job basically is we have three primary goals. Number one is to document the crime scene. So we do that in numerous ways. What we'll do is we'll take photographs, generally first thing that we do. The second thing we're going to do is we're going to take some 360 photography, which is kind of like when you're buying real estate and you kind of put you in the middle of the room and you can kind of look around on your computer screen to see everything in perspective. The other things we're going to do is if it's applicable, we're going to take aerial photography. We'll do that with either a drone or a helicopter. So those are different ways that we'll document the scene. And we'll also take measurements of the scene if we need to as far as documentation. And we're going to notate where all the evidence is. So that's something that we can recreate a crime scene later on if we need to.
In terms of the actual physical evidence, what do you do with, let's say, for instance, shell casing?
So normally we would document it photography-wise. Then at some point we would collect it. And then after we collect it, if it needed be, we'd process it. And then we'd have it ready to present to trial.
What do you mean by process it?
So in some cases, we may be looking for fingerprints or DNA. So if that's the case, we would that's what we consider processing if we're looking for a particular type of substance on the evidence. And in many cases, it'll be either DNA or fingerprints.
In this particular case, when you were tasked on the first floor, did you take photographs of the first floor?
I did.
Your Honor, may I approach the witness?
You may.
Your Honor, may I approach the witness?
You may.
Detective Christian, I'm showing you it's been previously marked as 2C or CC for state's identification. Can you please take a look? Detective Christian, do you recognize these nine pictures?
I do.
Are these a true and accurate representation of the photographs taken at 1200 building of the Marjorie Stoneman Douglas campus on February of 2018?
Yes, sir.
Your Honor, at this time, the state would request to move in states 2C, which is a composite of 9 photographs, in as states 29.
Any objection?
No objection.
Without objection, states 2C for identification will now be in evidence that is States Exhibit 29, a composite exhibit of 9 photos.
Your Honor, permission to publish?
You may.
And the cameras, I'm sorry, the TVs in the back are off, correct?
Court Deputy Unit, everything's off, correct?
Detective Christian, I'm not showing you. What's now in evidence is states 29. Do you recognize this photograph?
I do.
And what is it of?
This is building number 12, Marjorie Stoneman Douglas. This viewpoint is basically east looking west, and that is the east side of the building 12.
Now the prosecutor is going to get him to draw on some of the exhibits so that they can be remarked as exhibits and be used in the case. If you don't get these admitted through him, you can't get them admitted at all because he's the person with the most knowledge about how these exhibits were created.
And 110 would be the most east side of the building, near those east doors.
So looking at the, Your Honor, if you could put on, and you can show this.
The TVs can be on.
Yes, sir. Yes. Detective, can you repeat? Oh, wait for them to come on. Using the annotator, using the pencil, where were those approximately located?
So these were right here in quadrant 110, right in this area.
Okay. And that's 2 shell casings?
Correct.
Okay. Your Honor, may I approach the witness?
You may.
I'm now showing you what's been marked previously for identification as states 2. Do you recognize that?
I do.
Is that in the same or substantially the same condition as when you recovered it?
It is.
Okay. And what is it?
This is a fired casing recovered from quadrant 19, which would be in this area right here.
Your Honor, at this time, the state will request to move in states 2E for identification as states 30.
Defense, any objection?
No objection.
Without objection, states 2E for identification will now be in evidence that is States Exhibit 31.
Detective, you already circled where this was located, correct?
I did.
And that's the second, or the, to the left.
Correct.
Your Honor, may I approach witness?
You may.
Detective, I'm now showing you it's been previously marked as 2F or FF for identification. Do you recognize this?
I do.
And is that in the same or substantially the same condition as when you recovered it?
It is.
And what are they?
These are 20 fired casings recovered from quadrant 18.
Now, after that very long and somewhat boring exposition of how these photographs got taken and marked for evidence and put up on the board and marked on, the prosecutor turns the witness over to the defense, and watch what happens.
Your Honor, this time the state has no further questions for Detective Christian.
Okay, cross-examination, go ahead.
Defense has no questions.
Because the state has the burden of proof, it has to bore the jury with a lot of technical details. But the defense has the lovely ability to stand up here and say no questions, because nothing they could ask this guy is going to advance their case. And so they don't ask any questions, thereby telling the jury, hey, this guy didn't hurt our case. That's actually a pretty brilliant move. And then in this next clip, you will see one of those things I've talked about frequently here, which is that, words are the testimony that gets written down in the transcript, but the actions of the person testifying tell an entirely different story. I would really love to have somebody tell me what they think this witness is really saying at this trial. So let's watch her testify.
Can you please state your full name and spell your full name?
Sergeant Gloria Crespo, Crespo.
Gloria?
Yes, sir.
Okay. Mr. Kilburn, you may inquire.
Thank you, Your Honor. Sergeant, what agency do you work for?
Broward Sheriff's Office,
Now, going back into February 14th of 2018, what unit were you in?
crime scene unit.
And what was your main responsibility in the crime scene unit?
I was a crime scene detective.
What do crime scene detectives do in general?
We go to scenes and process scenes,
And by process, you mean things
collecting
like-
evidence, photographing, documenting.
So how much does that weigh, would you estimate?
About 12 pounds.
Okay. Is it your choice to wear that vest?
Where I'm dressed right now, absolutely not. I have to.
Okay. Why is that?
Because in this uniform, Broward Sheriff's Office says we have to wear this vest.
Okay. Going back to your SRO days pre-2016, did you wear a vest?
It was our choice.
It was your choice. But was it offered to all school resource officers who chose to wear a vest that
Yes.
they could? They were available, they were at the station or the substation.
No, they were with you.
No. I'm saying when you got that vest, you got it from BSO.
Yes.
Either from headquarters or from a substation, but it was given to you upon your request.
Well, it's given to us, not annually, every 5 years. But we're measured, and it is given to you before you go on the road.
Well, I don't know how you viewed that testimony, but it seems to me that she's not really cheesed up about testifying here, and she probably doesn't like the idea of testifying against a fellow deputy. And then again, at the end of her testimony, the same thing happens. Watch.
Okay, cross-examination.
No questions.
And again, that's the right move. If what she has to say is not going to help the defense case, you send the signal that nothing she said was really of very much importance to the overall case. So, as you can see, this is not much like LA Law and other crime shows or crime dramas like Law and Order. This is not rapid fire, getting to the point quickly and all of a sudden, you're done with a trial in 1 hour. It takes a long time to get evidence in. You have to lay the foundation. You have to show how somebody knew something, what they knew, where they came to be at that point, how they had the capacity to observe, what they saw. And you have to do it in that format so that you don't draw objections and so that the evidence gets into the record. Because if the evidence does not get into the record, then there is really not a whole lot anybody can do. If it's not there, an appellate court can't review it. That's what I have for you today. Thanks so much for watching. If you have the opportunity today, try to go out of your way and do something kind for someone. As always, I appreciate your viewership and I hope I can continue to earn your subscription. Thanks again for watching. Catch me down here at the beach next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.